Okay, so we are Group 4. Our employment law presentation was about whistleblowers and whistleblower protections. I'm Brennan Walker.
I'm Owen Miller.
I'm Rhea Lawson.
I'm Hannah Ross.
I'm Dawson Steven. What is whistleblowing? Whistleblowing is when someone reports bad or illegal actions happening in their workplace or organization. The retaliation is basically the company saying, get lost. For example, firing or laying off. A company would retaliate because any smart business does not want anything like that going on.
Who does whistleblower law protect? Whistleblower law is designed to protect an employee's right to expose their company's malpractice, and this law impacts every business as any employee can report a company for shady business practices. And the origins of whistleblowing were first brought to the Continental Congress in February of 1777. The Continental Congress passed legislation on July 30th to protect sailors and future whistleblowers. And an important quote pertaining to whistleblower law from the Continental Congress is, "It is the duty of all persons in the service of the United States, as well as all other inhabitants thereof, to give the earliest information to Congress or any other proper authority of any misconducts, frauds, or misdemeanors committed by any officers or persons in the service of these states, which may come to their knowledge."
A couple of agencies that were formed to protect whistleblowers are the Occupational Safety and Health Administration, the Mine Safety and Health Administration, the Office of Federal Contract Compliance Programs, the Wage and Hour Division, and the Veterans Employment and Training Service. So all of these agencies were just enacted to protect whistleblowers, and they do this by protecting them against retaliation from their employers. A couple different practices that they can use are anonymous reporting systems. So this protects the employees by protecting their identity from their employers. And then they can also just like they can sue the companies for laying off the employees and give them different benefits or help them keep their jobs. Just kind of protect them from retaliation against their companies. And then one of the large laws that was enacted to protect whistleblowers is the Sarbanes-Oxley Act, which was passed in 2002 after the Enron scandal. The Enron scandal was basically just a large company that was reporting false profits and hiding large amounts of debt. They did this by using illegal accounting practices, and once this got exposed, they had to pass the Sarbanes-Oxley Act to prevent this from happening again. A couple of things that this enforces is it ensures that public companies have to use like outside accounting firms just to keep them honest, and then it also established anonymous reporting systems, which allows employees to report these illegal services going on without fear of being exposed, and then it also can punish fraud much more severely, including long prison sentences.
So another key piece of legislation relating to whistleblower protections is the Whistleblower Protection Act, sometimes abbreviated as the WPA. This act mainly sought to encourage transparency and accountability within the federal government, specifically the executive branch. It was enacted in 1989 to protect federal employees against government retaliation for making protected disclosures. A lot of these disclosures consisted of illegal and unethical activities consisting of violation of laws and rules, mismanagement, wasting funds, abusing authority, substantial dangers to public health and safety, as well as employee censorship and agency policy decision making. Because executive branch employees and other associates fall under the U.S. Code of Civil Service, specifically under Title V of the U.S. Code, Section 3202B8 and 9 gives executive branch employees protections within the WPA. The WPA also imposes a reasonable belief standard when determining if a certain employee's disclosures fall within protection rights. And then another good test for determining whether a disclosure has reasonable belief is if another employee of an equal level in the company or government would agree with those terms of disclosure. So with that, we kind of transition into the Whistleblower Protection Enhancement Act of 2012. It was signed by Barack Obama to broaden the protections of the Whistleblower Protection Act. Specifically, it strengthened protections to military personnel and intelligence and security agencies such as the NSA, the CIA, and the FBI. It also allowed for informational disclosures to be upheld to Congress as well as other inspector generals and presidential executive cabinet members. It also reformed the Office of Special Counsel, or the OSC. Specifically within the OSC, it created a more expedited process for dealing with whistleblower retaliation cases, and also created a unit within the OSC strictly for whistleblower protection. Lastly, it prohibits agencies from using non-disclosure agreements to restrict reporting abilities. So essentially, an employee can't use an NDA to silence, or an employer can't use an NDA to silence employees in terms of whistleblowing or reporting disclosed information. So another key piece of legislation for whistleblower protections is the Dodd-Frank Wall Street Reform and Consumer Protection Act. So this was enacted in 2010 in response to the financial crisis of 2008, which was essentially the collapse of the U.S. housing market because a lot of Wall Street officials and high-ranking government officials were trading complex financial instruments and performing a lot of unethical activities with consumer money that resulted in crashing the housing market in the U.S. economy. The primary purpose of this act was to reduce risk and corruption within the financial system, protect personal consumer finances, and just overall promote transparency. Some of the key provisions seen within the act, a main one is Title X, which created a new Bureau of Consumer Protection within the Federal Reserve. So the Federal Reserve then became a huge authoritative rulemaking figure for a lot of these Wall Street or high-profile financial firms. And their job was to supervise unfair or deceptive activity to, again, protect those personal consumer finances. As well as another provision added was the Commodities Future Trading Commission's whistleblower program, sometimes abbreviated as the CFTC. This essentially paid monetary awards for whistleblowers who sought to disclose information outright against their employers. It also stated that employers cannot take any action to impede whistleblowers for directly communicating violations to their government or violations of the Commodity Exchange Act.
And then some situations involving whistleblowers would be corporate fraud exposure, which an example would be a company engaging in fraudulent accounting practices, and then health and safety violations, where safety protocols are ignored, making the workplace hazardous, and then environmental hazards, government misconduct, and data privacy violations. And then some important court cases would be in 1971 with Daniel Ellsberg. He was the one who leaked the Pentagon Papers, which detailed what was really happening in Vietnam. And when the press published the stolen documents, he was charged with theft. And then in Ellis v. Houston, 1991, a former employee of the Houston Police Department reported corruption and was fired. And ultimately, the court ruled in favor of Ellis, reinforcing the idea that employees should not face retaliation for reporting misconduct. And then more recently, in 2013, Edward Snowden revealed the existence of classified mass intelligence gathering surveillance programs by the US and UK. And he was charged with espionage and ultimately fled the country, and he still faces criminal charges for violating the Espionage Act.
In conclusion, whistleblower employment law protects workers or government officials who report wrongdoings or speak out against their bosses. Several agencies have adopted protections for whistleblowers. For example, the OSHA, the MSHA, the OFCCP. Key pieces of legislation for whistleblowers, Sarbanes-Oxley Act, the WPA, and the WPEA, Dodd-Frank Wall Street Reform and Consumer Protection Act. Thank you for listening, and we hope you feel better soon.